Please be seated. Alright, matter of prosecution against Yara Hobart. Do we have the accused here? Just confirming with regards to the accused Miss Hobart. Just to confirm, you have pleaded not guilty to murder. Can you confirm?
Yes.
Yes. Opening statement, please, prosecution.
Your Honor, members of the jury, we are here today to present a case that revolves around the tragic and unlawful taking of a life. A crime that violates the core tenets of justice and morality. The Crown alleges that the accused, Yara, is guilty of the heinous act of murder as defined under Section 18 of the Crimes Act 1900, which states that murder shall be taken to have committed where an act of the accused or thing by him or omitted to be done, causing the death charge was done or omitted with reckless indifference to human life, or with the intent to kill or inflict grievous bodily harm upon some person. The evidence we give today will demonstrate that all elements of this offense, actus reus, the guilty act, and mens rea, the guilty mind, are unequivocally met. Yara had motive, opportunity, and access to commit this murder. First, the motive. The victim, Yara's father, and himself, the offender, had a turbulent relationship for the past few weeks, culminating in an argument earlier that evening. The father, fearing for his life, had drawn out a large life insurance without telling anyone. Why?
Can you please be specific about a large sum? How much is a large sum? To some it could be hundreds, to others it could be millions.
$3 million. $3 million. The father, fearing for his life, had drawn out $3 million of life insurance without telling anyone why. Witness testimony will confirm that Yara explicitly threatened his father, stating, "I want to kill you," in those exact words, verbatim. The next opportunity. Yara claims he was at a cinema for the time of the murder, but his inability to produce a ticket or recall details of the movie raises significant doubt about his alibi. Who goes to a movie without remembering what movie it was, what popcorn they bought, where the ticket is? Finally, access. The lack of forced entry into the apartment strongly suggests that the assailant was someone known to the victim. Why would the father let someone stranger inside his house to kill him? Fingerprints on the murder weapon, a kitchen knife, by the way, tie the accused to the crime scene, as demonstrated by our expert witnesses. Additionally, we will show that a neighbor across the street, Ahmed, and a neighbor downstairs both witnessed the accused attacking the victim. The neighbor across the street witnessed the accused attacking the victim, and the neighbor downstairs overheard the argument and called in the incident. This both corroborates the timeline of events. In summary, the Crown will unequivocally establish beyond reasonable doubt that Yara unlawfully caused his father's death, fulfilling all elements of Section 18 of the Crimes Act 1900, and warranting a conviction for murder. We sincerely hope the jury will listen without bias and delivers a guilty verdict. Thank you.
The Crown referred to the members of the jury. One thing regarding the members of the jury, you really need to pay attention to the facts of the case. Ultimately, in a criminal trial process, where there is a jury, okay, I will not lay down that final verdict. So whether the accused is guilty or the accused is not guilty, it's not up to me. My role during this trial, considering we have a trial by jury, is to give that punishment as well. So I urge members of the jury, please be impartial. Obviously there should be no bias, and just take note of every small point regarding what both the Crown and the defence say. Regarding the Crown, you mentioned the neighbour. Can you just go back into that, please?
We have two neighbors here today who will be giving us witness testimonies. One is Adim Ahmed, who was downstairs at the time of the murder and witnessed overheard both an argument in which the accused explicitly states, "I want to kill you," to the father, and then later discovers the scene of the crime and calls in the police. And then our second witness, Mr. Ahmed Hafta, he witnessed the scene of the crime from across the street at the time it happened. And as he went to grab
Yes.
I agree.
Prosecution witness 1 to the stand. Please remain standing and raise your right hand. Shahrazad, move to the sorry.
Your Honor, members of jury, my name is Shahrazad, and today Zainab and I will be representing the defendant Yara Hoplos. This case is about proving innocence of a young man who was wrongfully accused of horrific crime that he did not commit. My client Yara Hoplos stands here today not as a criminal but as a son accused of murdering his own father. The prosecution's case is riddled with assumptions, inconsistencies, and lack of credible evidence linking Yara to this crime. The defense will show that Yara had no motive, no opportunity, and no intent to harm his father. Instead, he had a solid alibi for the time of their crime, collaborated with multiple pieces of evidence, and the night in question, Yara left her house after an argument with her father at approximately 7:50 p.m. to meet with his friend Atifa at Ed Square Cinema. Together they watched the movie from 8 to 10:15 p.m. as evident by the live 360 location data, Snapchat blogs, text messages, and her testimony. Yara returned home at 10:30 to discover the unimaginable, a murder scene. The prosecution will attempt to show my client is a harmless murderer able to kill a man that raised him for his whole life over one argument. They will rely on circumstantial evidence, unverified claims, and an incompetent forensic investigation, such as there was no evidence of blood on Yara, and the investigation failed to test his hands for rubber residue, which was found on the murder weapon. The murder weapon had traces of rubber, suggesting it was likely handled by a gloved intruder, further evidence pointing away from Yara. Furthermore, Yara's character and relationships demonstrate his innocence. While him and his father had occasional disagreements, their relationship was far from hostile. Yara lived with his father out of choice, showing love and respect regardless of the challenges. Over the course of this trial, the defense will provide evidence and testimonies from Atifa, Yara's friend, who will confirm his alibi, Yara Ahmed, Yara's mum, who will show his good character and share her own observations, and Ayan Fahad, the victim's solicitor, who will highlight the financial motives surrounding the father's insurance policy. Ladies and gentlemen, this stand for conviction is beyond reasonable doubt. This trial will unfold how there is not only reasonable doubt, but there is overwhelming evidence to prove Yara was not guilty of the crime. At the end of this case, we are confident you will see the truth. Yara Hoplos is innocent. Thank you.
Counsel of Defense remains standing. You mentioned that the accused went to the cinema. Is there anyone that can actually testify that she stayed for the duration of the movie?
Yes, the friend Atifa.
Okay, any receipts to say that she actually was at the cinemas? Any CCTV?
No, they were all thrown in the bin, and there was no CCTV.
We have
We have a Snapchat story from the defendant at the time, from the friend at the time, and we have a live.
Okay, with regards to the Snapchat story, unfortunately, in the court of law, that can't be used as social media. In today's technology, anyone can make anything. Do you have an actual receipt regarding the movie?
No.
Do you have any CCTV footage?
No.
Okay. Thank you.
We're going to do the witness oath. The court now calls Adeem the neighbour, prosecution witness 1 to the stand. Please remain standing and raise your right hand. Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the truth, the whole truth, and nothing but the truth?
Solemnly swear.
You may be seated. Thank you. The court now calls Ahmed, the neighbour, to the stand. Please remain standing and raise your right hand. Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the truth, the whole truth, and nothing but the truth?
I swear.
Thank you. The court now calls Mohammed, the police officer, to the stand. Please remain standing and raise your hand.
Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the truth, the whole truth, and nothing but the truth?
I do.
The court now calls Khalid, the forensic officer, to the stand. Please remain standing and raise your right hand. Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the truth, the whole truth, and nothing but the truth? Thank you. The court now calls Diara, mother of the defendant, to the stand. Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Nancy. The court now calls Atifa, the friend of the defendant, to the stand. Do you solemnly and sincerely declare and affirm that the evidence you will be giving is the whole truth, and nothing but the truth? I do. Thank you, Nancy. The court now calls Leanne, the father's solicitor, to the stand. Do you solemnly and sincerely declare and affirm that the evidence you will give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Nancy.
I'll just go back. Yara, just confirming you are the mother of the accused.
Yes,
So you're saying your daughter go to trial for murder.
yes.
So how does that make you feel as a mother?
It's heartbreaking, honestly, because I know it's something my son would never be capable of.
But what would be worse is if she's actually found guilty. Defense, regarding the criminal history of the accused, can you please just run through that?
There is no criminal history.
No criminal history at all?
No.
So are you saying that the accused has never committed no crime?
No, and he's 18 as well.
Police prosecutor, can you confirm please?
There's no evidence of any crimes prior to this.
No evidence.
I'd like to call up the defendant, Diara.
It's very clear that Ms. Hovlos has not been in the courtroom because she didn't really know where to stand. So I think it is quite clear. Ms. Hovlos, you do know you're in the Supreme Court. Now, can you explain your version of the events?
I had an argument with my father.
Not to me, to the jury.
I had an argument with my father, and then I left at 7:30, 7:15.
So how come you didn't change your time?
I had an argument at 7:15, and then I met with Atifa from 8. We went to cinemas from 8 to 10:30, 10:15.
So when you have an argument, do you look at the time straight away? For example, if I have an argument with my wife, do I say, we just had an argument at 9:54? Why the time? Defense, why the time?
It was approximate time. Because we're going off also what the neighbour downstairs had said, which said around 7:30 you heard the arguing. So we're going to assume that around 7:50.
Okay, so it's gone from 7:15, 7:30,
No,
7:50.
7:15 was by mistake, so 7:50.
What time was the movie? What time did the movie start?
Around 8.
So the movie started at 8 o'clock and the argument took place at 7:15. And which area do you live in?
Didn't go.
So we'll okay. Continue.
And then we finished at 10:15, and we parted at 10:15.
Which movie did you watch?
One.
Continue.
What's the story?
Anything else to claim that you are not guilty? Any defense you would like to raise yourself?
There are text messages, like the 16.
Your Honor,
Yes.
according to the script, the defendant does not remember what movie she watched. So her claiming that she watched Moana is incorrect.
I remember that.
Police prosecutor, can you confirm?
In the initial testimony that she gave me at the police station, she did mention that she had no idea what the movie was.
Alpha. I remember that one.
Can I speak on behalf?
Defense?
After we had run through the case and we re-asked her and we spoke with witnesses and they had told us it was Moana, so we had informed her it was Moana.
But what's the concern here is you've got the police prosecution that will start the investigation process. But during the investigation, the police is always the first at the scene. The police prosecution is stating, can you please repeat your words?
She did say in her testimony at the police office that
she did not remember. It's not to say that she did or she did not watch that movie, correct?
She had no evidence of what movie she watched.
Prosecution, I'm just going to argue there. So you're saying that she definitely did watch a movie, however, she did not recall the movie she watched, correct?
Your Honour, how can you say you watched the movie but you don't remember what movie it was?
That's what I'm trying to say, and that's what I need you to confirm.
So based on my knowledge and expertise, I would say that she did not watch the movie because she didn't remember what movie she watched.
So your knowledge and expertise is one thing, but during that questioning, did you question the accused about the movie she watched?
Yes, I asked her if she remembered watching the movie and she couldn't answer.
Okay, and is there video, audio recording of that to confirm?
I put it in my initial police report.
Okay, well, that prosecution.
We object to the statement
Please
that
rise if you object.
we object to the statement that the accused watched Moana because Moana hasn't come out at the time of the offence.
I'm going to accept that objection. So moving forward, matter for the prosecution. Once an objection is accepted, that simply means that the accused, Ms. Hoblos, stating that she watched the movie, being Moana, we're not accepting that. So,
Can I object to that as well?
Yeah.
Moana 1, not Moana 2.
In cinema?
In cinema, was it screening? Some people.
Moana one that came out.
Okay.
Can you explain Your Honour?
yes,
So my client states that she does not remember the
please
movie she watched.
face the jury, don't face
My
me.
client states that she does not remember the movie she watched because she was in a state of trauma after finding out that her dad had passed away and immediately being questioned by the police. Thank you.
Okay, continue, please. I'm going to leave there, continue your chain of events, please.
And then I came home I came home at 7:30 and then I saw 7:30.
Can I just go back? I think with regards to the accused, Lord, please, there is definitely a major discrepancy, and this is something that the jury really needs to pay attention to. Timing is very important. Yeah, it's one thing saying you did something at 8, but it's something you're saying you did something at 8:30. We're having an issue here with timing. Let alone the movie, we'll put that aside. Let alone actually go to the movie, or whatever movie you watch, that's different. But the issue we're having now is the timing, okay? Because if we can't agree on the time, that means the chain of events will actually be thrown out. So once again, regarding the accused, if you want, Ms. Hoblos, you can call upon one person from your side, criminal defence, or witness, to testify against what you're saying. Would you like to call anyone?
Yes, please.
Who would you like to call?
Atifa. My friend.
Call officer, please.
I call upon Atifa to the stand.
Please introduce yourself and outline the relationship between you and the accused.
My name is Atifa. I had a secret relationship with Yara Hoblos because my parents were strict and they wanted me to focus on my studies. So I thought I would let them know in the future when the time was ready. On the day of the offence, at 7:45, Yara texted me saying that she wanted to hang out with me and that she had an argument and she wanted to cool down. So I suggested
Can I just stop you there? 7:45, timing has changed, which is fine, before I mention anything to the jury. Is there evidence of 7:45 PM of text messages?
yes.
Can we please see? If there is, members of the jury and members of the public, if there is solid evidence that the accused did message a friend at 7:45, we can accept the timing. Therefore, members of the jury, when I mentioned earlier that the time cannot be accepted, if they can prove that it is, we can accept it. So if it is proven that text messages were sent, we can accept it.
Okay, so here we can see that Yara texted me saying, "Hey Tiff, you want to meet up tonight?" And I asked like, "Oh, is everything okay?" Because she said she had a rough evening. And she was like, "Yeah, I just had an argument with my dad, I need a break." So I was like, "Okay, let's catch a movie," because we want to distract her from whatever happened and we want to cool down. So she told me to pick the movie and I was like, okay, it'll be a surprise for her. And we decided to meet up around 8 and that's when we met up and we watched the movie and we were together until 10:15 and then we parted ways and then she went home. And I was
Where's the timing?
it's at the top of the screenshot. Go ahead.
Evidence accepted. continue.
Continue the chain of events.
Okay, so that was a kind of video. So before I met up with Yara, I also filmed like a vlog on my Snapchat saying like, oh, we're gonna meet up at 8 o'clock. And then while the
Objection, Your Honor, that's, sorry. Objection,
Please
that's.
remain seated.
Thank you. Yes. So I made a vlog prior to meeting up with her on my Snapchat story, and in the vlog I was talking about like, oh, I'm gonna meet up with her and we're gonna watch a movie together. Yes, in the vlog I mentioned Moana 2, but I just got the name mixed up. I meant to say Moana 1. Sorry, human error, mistake happens. Okay? And then while we were at the cinema, I have a screenshot from my story which the judge didn't
Your
want
Honour,
to,
please.
Your Honour didn't want to accept. But I do have a screenshot from my Snapchat story where we both had popcorn and drinks and we were in the cinema.
Can we please just show that to the members of the jury and the public? Can you explain this, please?
So here, as you can see, that's me and Yara sitting with our popcorn, and that's the screen in the cinema. We're there, and we're just like trying to cool down from whatever evening she had. And as you can see, the time is 8:15 p.m. And
I want to challenge something to them. You've mentioned, and this is for members of the public. Obviously here, looking at this evidence, all we can see is popcorn and we can see Coke. But what I want the jury to take into account here, the jury, police prosecutor and Crown, what you need to think of here is, where are the faces? Anyone can take that picture online. Yes?
in the trend of social media, when you're posting on your stories, people don't always expose their faces for the sake of aesthetics. People just take photos of food. That's exactly what I'm
Evidence
doing.
rejected. Continue, please. Any other channel events?
I had the vlog which I filmed of myself going to the cinema, meeting up with Yara at 8 o'clock.
So when evidence, members of the jury and members of the public, so we have a legislation for those that may not be aware, the Evidence Act. What we need to look at is the evidence admissible or is the evidence inadmissible? The first piece of evidence, which we saw the timeline, okay, the messages, we are accepting that evidence. So members of the jury, please accept that. The Snapchat story that we just saw, inadmissible evidence. Why? Because there is no faces within that picture. So therefore, we are not accepting that. Now, can you please recall this?
Yes, I filmed this before the meeting up with Yara at the cinema.
Alright guys, it's 8 o'clock right now and I am going to watch the movies with Nara. So we're going to watch Moana 2 and I will let you know how it goes.
Your Honor, I object.
Based on,
Inconsistency. How?
can you please,
I object on inconsistency because the photo that you gave of the popcorn and drinks, the outfit does not match with the outfit that you have. I'm responsible for that. I'm wearing the black body top.
I didn't approve. Continue.
Therefore, we don't see that as credible evidence that you and Yara were at the movies on that day at that time.
Evidence accepted off the video. Prosecution, I'm going to rebut what you said. Your evidence has been accepted. Is it to challenge the prosecution? Go for it.
Okay, as you said, I was wearing the black body top sleeves in the video. In the screenshot, if you want to pull up to the popcorn screenshot, Yara is the one with the beige jumper, not me. I'm the one sitting next to Yara. So you can see my hands, and you can see that Yara's wearing the beige jumper because I wasn't wearing that. I was wearing the black sleeves. So I'm next to it.
Evidence accepted. The video, okay, we will accept. And the message chain will accept. However, members of the jury, okay, the one that is inadmissible, the one that we would not accept is that Snapchat story.
Which one? The vlog or the screenshot?
No, the screenshot.
The screenshot.
Also, we have.
Please remain seated.
I call upon Yara to state her case.
Members of the jury, it's very important for you once again, take into account exactly what the witness has said. And just a piece of evidence for everyone, okay? Always in a criminal trial case, we need to remember not to let emotions take over. I know we all want to stand up, scream, shout, but we need to obviously make sure emotions don't take over, because once they do, then we start saying whatever, okay? We just talk out of emotion, and therefore, you may actually say something wrong. Please introduce yourself.
My name is Yara Applet, and I'm the mother of Yara Hoblos, and I'm one of the witnesses for the defense.
Chain of offense, please.
So, at the time, allegedly my son committed this horrible crime, I was at my house. I wasn't aware of anything that was happening at this time. I was at my home by myself in Parramatta, and I was on a work phone call from about, sorry, I was on a work phone call.
What do you do for work?
I'm a foreign correspondent. So I generally travel a lot for my work overseas as a journalist. And at the time this was apparently occurring, I was on a phone call with a work friend. I think it was around 9:45, and it lasted until about 10:15. And then from then, I obviously wasn't aware of anything that was happening, and I got ready for bed and then went to sleep. And then later on, I found out that my son had been arrested, and I immediately went to go see him.
Did you know about the relationship that your son has with the witness?
I was not aware of the relationship between him and Tifa.
So would you say you and your son are close in terms of sharing a bond with each other?
Close to a certain degree. I would love to be closer to my son, but unfortunately he lives with his father, and I only get to see him about once a month. So we don't get to see each other as often as I would like, and I would like to see him more, but unfortunately it's just because of the divorce we can't see each other as often.
So your son wasn't on good terms with you and didn't want to visit you anymore.
I was not aware of that.
This was a part of the police report. Can you explain why?
I'm not sure. All I ever did was love my son. I don't understand why that would be the case. I was a good mother to him. All I ever did was love him. I provided for him. And if anything, maybe it's the father speaking. We weren't on good terms. But I always felt like I was on good terms with my son.
So you're shifting the blame on the father. You mentioned the father. What blame are you shifting on the father?
I'm not shifting the blame, but I just know that my son would never want to do something like that. It's not him. My son is a good person.
Remain standing. Crown, prosecution, cross-examination.
You say that your son is not capable of any act of murder, right? You're saying your son isn't capable of murder.
That's correct.
How would you know that?
Because I'm his mother. I know my son.
Okay,
I know him.
let's talk about that then. From what ages did your son live with you full time?
My son lived with me from obviously when he was born to about 3 years old.
Okay, and from then on you say that you saw him once a month?
That's correct.
Your Honor, members of the jury, would you say that a mother who sees her son once a month for the entire 15 years that have to pass since the accused was 3 would know their son well? If you know your son so well, let's accept that. You know your son, you gave birth to him, you obviously know the values that you instilled in him once a month, every year, for 15 years.
That's correct.
Let's talk about the father. Do you think the father was capable of upsetting your son to this degree?
To a certain extent. We obviously had our issues. That's why I divorced him. But
Can you go deeper into that, the divorce? Why did the divorce happen?
the divorce.
Rejected. We're not here to hear about that.
Objection.
Continue, please.
Right, yes.
Then can you talk about the father?
Talk about the father, not about the divorce.
The father, I do know that we obviously argued a lot, but I know that my son respected his father. They had a good relationship. They obviously did argue from time to time, but as with any child and their parents, no relationship is perfect. So from what I know of, and from what my son has told me, and every now and then they would have the occasional fight.
Can you testify as to what the fight was about? That
No,
day.
I cannot.
That day specifically.
I cannot.
Your son hasn't told you?
My son has not told me.
Your son that you know very well?
He has not told me. And I respect our relationship as he is closer to his father than me. Sorry. It's really hard for me, sorry.
Take your time.
I respect that his relationship is closer to his father, and as I don't, because I only see him once a month, I fear that I may cross certain boundaries and that my son might leave me forever.
Do you hold any resentment to the father that would lead you to testify for your son in this case?
I don't hold any resentment. I think it's been a long time since the divorce. So that was all left in the past. I don't have any kind of relationship with the father anymore. It's just me and my son.
So based on what you've told me, you have every reason to want your son to live with you again and not your father, correct?
Isn't that would be what every mother would want. But unfortunately, it's not possible because I travel a lot for work. So it's not putting my son's best interests at heart if I'm barely around.
Your son is an adult now. He's 18 years old.
That doesn't change the fact that I want to see him.
Your Honor, that is all. Thank you.
I'd like to call upon the defense for cross-examination. Cross-duress.
One point that I don't think I'm willing to accept, and again, this is just could be personal bias here, members of the jury, so don't quote me on it. The mother stated that, of course, the comment was, of course, I've had a good relationship with my son, I wouldn't do anything to hurt him. But in the court of law, there have been many cases, one in particular, where the daughter had actually decapitated her mother. So that comment of saying that, of course, I won't do anything to my son, anything is possible. So from that point on, members of the jury, I really want you to take that into account. There was a case in 2019 where a daughter had actually cut off her own mother's head. So therefore that comment, okay, I'm happy to throw it out. Defense.
I'm going to ask you, what was your relationship like with Yara?
I would like to think we had a good relationship. We were obviously a lot more distant because I didn't see him that often. But he was a good boy. We had a good relationship. He's been respectful. Of course, he's a child still. He's still my child. So we would argue every now and then. But like I said, it's just typical parent-child stuff.
Yeah, and can you confirm your whereabouts during the crime?
And the crimes apparently occurred. I was at my house on the phone.
Do you have any evidence?
I
I believe you have
had
a screenshot for the court time.
Let's go, sure.
Yes. As you can see, this is evidence of the mother's alibi at the time. But I also want to ask, what was Yara's usual behaviour when you catch up every 3 months?
Yara has always been respectful. He's a brilliant boy, honestly. Don't think it too possessive. He's a brilliant boy. He's always been the top of his class. He does well at school. I hear a lot about the good relationships he has with his teachers and his friends. So I know my son, and I know he would never be capable of something like this. He has too much love to give.
Okay, thank you. That's all, Your Honour.
Please go back to that image. So there was a phone call that took place between, can you explain the image?
It's just to show the witness's alibi at the time.
The members of the jury, please pay attention to evidence.
And this is just to show the call, which was started at 9:44 and continued for 27 minutes and 44 seconds, as you can all see. And it was to a work colleague called Tina. Oh, Tiana, sorry. Yes.
What time did the call end, please?
Reject. Please don't ask the defense question.
Is that everything?
Thank you. Any further comments?
I believe my son. didn't kill his father. Whatever the prosecution might tell you, my son isn't a murderer. Thank you, Your Honor, and jury.
We also have a forensic evidence expert witness here. The role of the expert witness is to actually testify and to actually provide the jury with all pieces of evidence. The expert witness does not take any side. The expert witness will not be on the side of the Crown, will not be on the side of the criminal defence. His role is simply just to answer any questions from the police prosecutor, counsel of defence, and Crown prosecutor.
I'd like to call upon expert witness to speak to this.
My name is Khaled, and I was a forensic office investigator for this case. Upon arrival at around 11 p.m., I entered the house, or entered the apartment, and immediately saw a dead body with deep incisions around the tools area. There was a large kitchen knife under the dead body, which we obviously ran through with forensic analysis. We had two sets of fingerprints, one of which is leading to the son, the other leading to the father. And there were also traces of rubber on the knife, which shows that the accused, or you see our accomplice, tried to cover up the murder with using rubber gloves.
May I ask my
So are you stating that she did commit the crime as an expert witness? Counsel of defence.
Examination. Alright, was the forensics report done and signed off by you?
Yes, and it's it.
And is it? Okay. Are you aware of the forensic wait first. Were there any traces of rubber on the knife?
Yes, there was.
And given that the knife was held by several people during the investigation, can you say that the residue on the knife was linked to the accused?
Yes.
And the accused's hands were never tested for the residue of rubber? No. So how can you confirm
Is
that?
there any images of the knife?
Yes, there are.
Your Honour, in
There
the
is.
exhibit,
Can we just see images of the knife, please?
It's the evidence back of the crime.
Can you please just run it through the evidence?
Yeah. So obviously the knife had stains of blood, which obviously leads to the father's blood, and the one set of fingerprint from the son was found on the handle part of the knife, so the black rubber part of the knife. With the father's fingerprints found on the metal part.
Defence.
So just asking again, was the accused's hands checked for rubber residue?
I'll say sorry.
Was the accused's hands
Yeah.
checked for rubber residue as you stated? They were? The accused's hands
Yes.
were tested. Why wasn't it in the forensics report?
What was the rubber?
No, the hands of the accused that were tested and had rubber residue on the hands.
We didn't include it.
Okay, so is that accurate?
It is accurate.
Okay. So
Why
Your
didn't you
Honour,
include it?
The fingerprints?
Yeah.
We didn't decide to put it in the evidence analysis.
Your Honour, can I say? So basically the forensics team has failed to, so since they're saying they didn't test the accused's hands for rubber, if it's not in the forensics reports, it's a failure to, no, it's under section 137 of the Evidence Act. This completes of incomplete forensic procedures which create unfair prejudice against the accused. Okay, basically it's inconclusive finding since it was not left in the evidence report. So evidence of this nature should be excluded as it does not meet the required standard of reliability. Thank you.
Members of the jury, very strong point which the defence just brought forward. So make sure you guys understand exactly what she has said. Okay? She's going against that piece of evidence. So once again, be very aware of what the counsel of defence has just stated. Any challenge, prosecution?
We do challenge.
Yeah.
So
Challenge based on what, please?
based on inaccuracy. Basically, the reason that the forensics team decided to exclude the rubber from the forensics report is because the rubber on the residue on the rat knife came from the forensics team handling it with their rubber gloves to ensure procedural accuracy. So that rubber residue that was part of the evidence, it wasn't actually from the crime scene itself, it was from the handling.
We will adjourn. So we're going to go to the last individual. And then from there on, we will take a break once the court officer dismisses everyone. Let's counsel officer.
Yeah, so I'd like to object from what they just stated about the rubber. So you stated that the rubber residue left on the knife was then not from the accused, as you stated. It's actually from people handling it. How does this prove that my client was guilty of holding this knife or even putting on these gloves to use this knife? How does that prove that if it was done by one of yours?
Based on my experience, the rubber gloves are used usually to hide the fact that somebody stabbed someone.
Okay, but it was done by one of your people, not my client. So
I
how
don't know
does this prove? Because you just stated that.
Objection, prosecution. Please do not interfere with both parties.
Yep, so your prosecution lawyer just stated that it was not done, the rubber residue on the knife was not from my client, it was actually done from one of your people examining. So how does this prove that my client's guilty?
The DNA fingerprints as well.
Okay.
Your Honour, may I just add that if the
No, please remain seated.
Can I talk about the DNA?
Please remain seated. Court officer.
The court is now adjourned. We'll take a short break for 30 minutes. Jury remains seated.
Please be mindful of who you speak to during this time. Jury, you'll remain seated.
Honourable Judge, members of the jury, our esteemed audience. The defence has presented a case filled with inconsistencies. Their expert witnesses that have provided testimonies also filled with inconsistencies. So, Yara, the offender, was called and asked about what her day was like on the day of the crime that she committed. The offender could not recall the time of the offence, what the argument was, or the movie that she watched, which is her solid alibi.
Your Honour, objection, the movie is
Sit down.
Next witness, Viara, the mother of the accused and the divorced wife of the victim. She claims that she had a good relationship with her son that she met with once a month for 15 years. What type of good relationship can be fostered once a month in 15 years?
Was there custody arrangements or anything?
The defense has not given us any information about that.
Continue.
Next is Atifa, the secretive friend of the victim, which, by the way, the mother was not aware of her relationship with the accused. She's presented us with a video of her going to the movie with Yara, which is her evidence, right? But there was no, Yara was not in the video. So who could say that that was actually proper evidence? There's no evidence to show that they actually watched the movie. There's no CCTV footage. There's no receipts of the, there's no movie ticket. And Atifa claims that they watched Moana 1 first, which, by the way, they first stated that they watched Moana 2, which they then changed to Moana first. Again, inconsistent. But they have not given us any evidence of any screening of Moana first happening at, where did they watch the movie? Expo. They have not given us any evidence of Moana first screening happening on the 21st of April at Expo. So, thank you.
I'll now call upon the defense to give a recap of the initial.
So, Your Honour and members of the jury,
basically, the prosecution has stated that, and the witnesses that they brought forth, for example, Khalid as their forensics investigator, who have stated that there was rubber residue found on the knife that was originally said by him to be from, again, my client, and then from his colleague. From his colleague stated that no, this rubber residue was actually found from people handling this. Does that not state contamination of evidence under Section 137 of the Evidence Act, 1995? Basically, this is also stating under Section 165 of the Evidence Act, 1995, because this evidence seems to be inadmissible, as it failed to provide sufficient evidence because it was tampering with it. This is not standard procedure, part of the forensics procedure. It's not a standard procedure used by forensics, as others stated, because this rubber that was found was allegedly done by the people handling the evidence. Thank you.
I'd like to call upon the ship to say this.
Your Honour, members of the jury, I was doing my daily patrol at around 10 o'clock at night in the court.
Can you please introduce yourself to everyone in your role?
My name is Mohammed Rashid, and I'm the police prosecutor, and I was the police officer who attended at the crime scene.
Can you describe what you saw when you arrived at the crime scene?
I saw a dead body lying down on the ground. There was a pool of blood around the dead body, and there was a knife right next to it.
Based on the neighbor's identification being Adim and your investigation, why did you arrest Yara?
So when Adim walked in, when Adim gave me his testimony, and Yara walked in around 10:30, Adim started claiming that Yara was the son, and he continuously pointed at Yara. So based on reasonable suspicion at that time, I did arrest Yara and took her down to the station.
What did the accused claim when questioned about her whereabouts at the time of the murder?
Honestly, she had no idea. We got to the police station and I asked her where she was. She said she was at the cinema. So I continued to get details after what movie she watched. Again, she had no idea what she was watching because apparently she was too upset by whatever argument she had with her father. So I asked if she had any evidence or proof. She couldn't give me any sufficient evidence at the time. I asked for any CCTV footage. She said that the cinema, the CCTV wasn't working, which I further found out that was true by the cinema when I went down. And I asked her if she had any proof that she paid for a ticket or any proof that she was at the cinema. She said she paid in cash, therefore she had no evidence to support the claim that she was at the cinema.
Did you say CCTV footage wasn't working at a cinema?
Yes, that's
And is that inside the actual cinema or that whole complex where you enter?
the whole complex.
Continue.
So just to confirm, she didn't remember what the movie was. She had no tickets or any receipts to show that she had actually gone to watch a movie.
No, not at all.
Alright, that's all. Thank you.
Defense cross-examination.
Oh, sorry, 1 second. We
Wait,
have.
seated.
So you believe you've done your investigation entirely to track where Yara was at the time of the crime?
Yeah, of course.
Okay, so what if we were able to tell you that we were able to use Live 360 GPS tracking, which shows that Yara actually did go to the movies and left at around the time she claimed?
Well, then why did she tell me that when I got to the police station?
She did.
She didn't give me any evidence.
Especially when someone's just come back from her father being murdered, I'm pretty sure that's the last thing on her mind.
Seems very convenient for the client.
Can you please explain what live tracking GPS
Okay,
360
so basically, so like you see, is an app you have with usually friends or family, and just so they can see your location throughout the day.
But was consent provided by the accused for that to go through?
Yes.
Can you please confirm
Yes.
that consent was provided?
And so basically, they're able to see where you've driven or where you've walked. And see, we see this, which was taken today. If you scroll down, it shows that Yara left on a 70-meter walk, which is exactly the distance from her house to the location.
70 or 700?
700, sorry, what did I say? 700-meter walk. She left at around 7:53 and arrived at around 8:08, which matches up with her claim and the text messages from Atifa. And that was around a 15-minute walk. And we can see there's also the route back home, when she left at 10:15 and arrived at 10:30, the time which the police officer saw her arrive at that time.
Members of the jury, please pay attention to that. Snippet of law, evidence will be accepted. Counsel of defence, any further
Your Honour,
comments?
I object.
Please wait for your turn. No objection.
So I'd just like to ask the officer, you stated in your opening statement that there was no like investigation done for the fingerprints or any tests done.
I didn't say that.
You didn't say that in your opening statement?
Forensic secretary said that.
Okay. So what specifically was conducted during your investigation period?
So when I got to the crime scene, I took photos of the crime scene, and we have it on body cam. If the prosecution wants to know.
So can you specifically explain the procedure you followed to ensure that the evidence was not tampered or contaminated with during your investigation period?
Yeah, of course, I'm a police officer. I'm actually the chief of this investigation, so I don't do any wrong things while I'm going to the crime scene. I follow all procedures as per my training. Got to the crime
Attention
scene.
please, can all students from year 3, learn 5 and 6 participating in the Quran competition, please head over to the Mariam room. That's all students from 3, 4, 5 and 6. Please head over to the Mariam room if you're participating in the Quran competition.
I got to the crime scene, and once I saw the dead body there, I closed off the crime scene. I took my photos. I bagged the knife as evidence for the forensics to come and examine the knife. And once I had a dean who was a witness, he came down and he was willing to give me his testimony, so I took his testimony there.
Okay. And then how do you explain, as your fellow prosecution lawyer had said, that there was actually rubber residue from your people working on the knife? How do you explain that?
I'm not a prosecution lawyer, I'm just a police prosecutor. So the residue that was on the knife, it wasn't examined by me, that was by the forensics department. My job was there to collect and bag the evidence to make sure that nothing gets tampered with.
Okay, and the neighbour that you became a dean, how do you know that he was not biased? Because of, as it was stated by him, that there have been issues with the accused as he plays loud music and the neighbour constantly complains.
Well, when I get to a crime scene and I see a dead body lying down on the ground, it's not my first job to start questioning the testimony. The one who gives me the testimony there, I'm going to take it at face value because there is a dead body on the ground. I can't just go, well, let's leave the dead body on the ground. How about you? How about what your testimony says? Why did you give this testimony? I took the testimony at the start because there was a body on the ground. I used all reasonable suspicion to make the arrest when I walked in.
And did you take reasonable suspicion on the neighbour as well?
What reasonable suspicion would there be on the neighbour if they come to give me a testimony?
How do you know that they didn't do it and are calling it in to make it look like they didn't do it?
Well, at the
Is it not your job as a police officer to take everyone as a suspect and then clear them out?
why wasn't I informed in the investigation process? And if Yara had claimed that the neighbour was the one who was doing the thing, why did she tell me that at the station?
Because she was in a state of trauma.
I'm going to stop
So
you both
that's
there. The role here is not for you to both challenge each other. It's both, the process is just strictly evidence, but now we're moving into challenging each other. So Counsel of Defence, can you please? Prosecution, last chance, challenge. Or to re-question or to bring forward any pieces of evidence by the police prosecutor.
Your Honor, we bring forward some evidence in body cam footage from the officers responding to the scene. Your Honor, members of the jury, as you can see, Officer Bashir entered the crime scene at 10 p.m.
Objection.
Yeah, please.
Please, come on.
Continue.
Officer Bashir entered the crime scene at 10 p.m. and witnessed a body on the ground, the body of the accused's father. Now, that body on the ground laying there, that was killed with a knife that was found at the scene by this responding officer.
Yep.
And this responding officer, did you confirm when you handled the evidence, the knife that you found, and you put it in a bag, did you use rubber gloves as following the protocol?
Yes, of course.
Of course you did. That, I believe, explains the presence of rubber residue which was omitted in the forensics report that we have provided as evidence as well. If you pull that up, please. It provides an explanation for the rubber residue of the gloves left on the knife, which were omitted from the forensics report due to irrelevance, as the officer on duty and the forensics officer both followed protocol according to their separate jurisdictions. We believe that the evidence that we provided with the fingerprints on the knife is admissible. If you have a look, this is the kitchen knife that was found next to the body, and as our forensics officer did exploration of the evidence, we saw that there were two sets of fingerprints identified, one of the victim and one of the victim's victim's son, the accused.
Just on a Crown prosecution for a minute, apologies. Just on the jury to remember, be mindful of one thing. The video that we saw of the body, we're not trying to prove that the person has been killed. We know that. So that video, yes, it does have weighting, but please do not look at that video and definitely point to the accused and say, guilty. What we need to determine is, yes, there was a body on the floor, but don't steer away from the actual case. The case is the accused guilty? Now, obviously, every criminal case, there's always a dead body. A police prosecution will always have photos, will always have videos, but please do not steer away from the case just because of that one video.
If we scroll down just a little bit, we can see that the fingerprints identified, print A1 is located on the handle left side near the bead lace, full print of the right index finger of Yara Hoblos, the offender. Now this corroborates our story that Yara used the knife to stab the victim, the father. Now you may ask, as a jury, why would Yara feel the need to wear rubber gloves? Well, she didn't. She didn't because due to the kitchen knife being in their own kitchen, she didn't see a reason for anyone to suspect that her fingerprints would be on that knife. That is all. Thank you.
Not just
Is that object based on what?
the evidence inconsistency.
Yeah.
Because in the video and the body cam, we can see the police opening the door when in the claims it says the door was already wide open.
Okay, objection. Approved. You might not that.
Competition participants for the million rupees. For year 3, 4, 5, and 6 competition
Chairman, can you please state your position?
My position in this case was a forensic investigator. Obviously, my job was to analyse evidence and conduct a forensic analysis to to prove the accused.
We'll start with cross-examination from the prosecution, please. If there's any questions that you would like to raise for the expert witness. Counsel of Defence, you will go next.
What were the findings from your analysis of the murder?
So the large kitchen knife obviously had two sets of fingerprints, one which is leading to the son's DNA and the other the father's DNA.
Did you find any other significant evidence at the crime scene?
There was the rubber gloves, but again that was
So traces of rubber.
Yes, traces of rubber.
Alright. Was there any sign that the apartment had been broken into?
There was not. There was not.
In your professional opinion, what does the absence of forced entry suggest?
Forced entry suggests that intruders obviously are the ones who are trying to get into the apartment. So, with the absence of forced entry, this means that somebody from inside the apartment, who lives inside the apartment,
Someone had access to the
Yes.
apartment.
was active in the apartment.
What is the significance of the traces of rubber found on the knife?
Well, the significance of this rubber traces is that it was conducted by forensic officers.
So the traces of rubber were not
That's the
found.
forensic investigation.
Exactly. Yes. Thank you. That is all yours.
Counsel of Defence, please.
How can you confirm that the rubber was from the officers and not from the offender?
Because we use rubber gloves to analyze
Yeah, so
evidence.
does that mean that you're tampering with evidence?
No, we're analysing the evidence and we're using rubber
But
gloves.
you still left marks. And under section 3137 of the Evidence Act, that makes your evidence inadmissible as you tampered with it. Even though it's still a rubber mark used from blood, you still tampered with it.
Objection.
Can I also say, can she continue?
Also objection speculation, because they, as she just asked him that, or do you think about the forced entry, how would he know he's part of the forensics, not part of like the police officer? Also, I'd like to state that given that kitchen knives are commonly used household items, how can we definitely prove that the DNA found on the knife from the accused was at the time of the murder and not from a previous incident of handling the knife?
Well, we ran the DNA through, and it was a fresh DNA. It wasn't an old fingerprint.
Okay. But as we had stated, the accused wasn't there at the time of the murder. So I'd also like to say that, Your Honour, this evidence is irrelevant under Section 55 of the Evidence Act, as it fails to directly prove the central issue of the accuser's guilt, as we said that he was not there at the time. This evidence is only admissible if it is relevant to the facts in the case, however it is not. The prosecution relies on the presence of DNA and fingerprints on a kitchen knife. A kitchen knife is a common household item, and the presence of DNA or fingerprints is not unusual or unexpected. Yes, it may be fresh, but couldn't you have used it that morning of? Without evidence showing the knife specifically used in the commission of the murder, this forensics evidence is not relevant to proving the accused's involvement in our crime. Simply finding DNA on the knife does not prove that the accused used it to kill. Again, they could have just used it the morning of, it was so fresh. It is highly speculative, objection speculation, and does not directly support the central issue of whether the accused actually committed the murder at the time that you are stated. As such, this evidence should be excluded for the lack of relevance.
Okay, with the Crown prosecution, we are going to follow the rule of objection here. You can only object one point that the defence has raised. You choose one. And please present it to the members of the jury. So members of the jury, the Crown prosecution will only select one point that they wish to object, and please specify your objection.
Your Honour, members of the jury, we'd like to object the assumption that the evidence of the knife and the DNA on the knife is irrelevant. This is because the murder weapon, the knife with the blood of the victim on it, the knife with the fingerprints of the accused who is sitting right there on it, cannot simply be rejected on the grounds of it being DNA that could have happened earlier in the day. As our forensics investigator has already told us, a man who has over 23 years of experience in the field, that DNA was fresh from that morning. And even if it wasn't, how can we logically say that the murder weapon used and proved to have been in the chest of the victim himself can be dismissed? That doesn't make sense. Let's object on that ground.
Okay, thank you. Crown prosecution, thank you. Helen.
I'd like to call upon Azim to come forward and say his piece.
I think, please take your case and your role.
My name is Zane, and I've lived in the same apartment for 10 years. I've known Yara and his father for about 8 years. Ever since they moved into the apartment above mine, I've seen them both almost every day over the years. I've become familiar with their habits and interactions. I've known Yara for many years, ever since she and her father moved into the apartment above mine about 8 years ago.
Sorry, just pause. Members of the public, is anyone here that's willing to talk, please leave. It makes it very hard for people to actually listen. So if you're sitting here, you're speaking, please remove yourself.
Over time, I've seen her almost every day and become familiar with her and her father's routine. While we never had close personal interactions, I've witnessed the tension between them, especially in the recent weeks leading up to the night of the incident. I wish I could say things between them were peaceful, but that wasn't the case. From time to time, I've overheard them arguing. It wasn't constant, but in recent weeks, their arguments became more frequent, louder, and more heated. Something had clearly changed in their relationship. On the night of the murder, at around 7:30 p.m., I heard another argument coming from their apartment. It sounded like the kind of fight they'd been having more and more often. I didn't pay much attention at first until I heard Yara's voice rise sharply above the rest. She shouted, "I want to kill you." Those words stopped me in my tracks. It wasn't something you could just ignore. I wasn't imagining the either. Her voice was very loud and her tone was serious, angry, and full of emotion. This wasn't a casual argument anymore. It felt much more dangerous. A few moments later, I heard the slam of the front door. It was loud enough to echo through the hallway, and I heard footsteps. Someone walking away quickly. I didn't see who it was, but I assumed Yara had left in the apartment in anger. I have to be honest, at around 10 p.m. that night, I was sitting in my living room, watching television, when I heard something that sent a chill down my spine, a scream. It was loud, panicked, and coming from upstairs. It wasn't just any scream, it was a type of scream that makes you realize something is horribly wrong. I rushed out of my apartment and ran upstairs to see what was happening. When I entered their apartment, I found Yara's father lying on the kitchen floor. He wasn't living, and it was clear he was already gone. The front door was wide open, swinging slightly, and there was no one else in the apartment. It was eerily silent. I didn't waste any time. I immediately called the police. Based on everything I heard that night, especially Yara's threat during their argument earlier, I believe she is responsible for her father's death. I can't forget those words. I want to kill you. After everything that happened, I don't see how it could be anyone else.
Thank you. So you're stating that the accused is guilty. Any remarks from the prosecution? Please.
Alright. Just to focus on some of the facts from his testimony, you mentioned hearing an argument earlier that evening. Can you tell us exactly what you heard?
Yes, around 10:30 p.m., I heard Yara and her father arguing again. It was loud and heated, similar to the arguments they've been having more frequently lately. During the argument, I clearly heard Yara yell, "I want to kill you." Her tone was angry and serious, and it caught my attention right away.
What time did the argument begin?
The argument began around 7:30 p.m. It didn't last very long, just a few minutes, but it was intense. Shortly after Yara shouted, I heard a door slam and footsteps, as if someone had left the apartment.
What did you observe when you entered the apartment after hearing the scream at 10 o'clock?
At around 10 p.m., I heard a loud, terrified scream from upstairs. I ran to the apartment and found the front door wide open. When I went inside, I saw Yara's father lying on the kitchen floor, motionless. There was no one else in the apartment, and it was completely silent. It was clear that he was already dead, so I called the police immediately.
Why do you believe Yara is responsible for the crime?
I think Yara was responsible because earlier that evening, I heard her shout, "I want to kill you," during the argument. Even what I heard and the fact that the front door was wide open with no one else inside, it seemed clear to me that Yara had carried out that threat.
From your own observations, what can you tell us, the judge and the jury, about the relationship between Yara and her father?
Yes, I've overheard them arguing on several occasions over the years, but it became more frequent in the weeks leading up to the night of the murder. Their arguments have grown louder and more intense. I've also had issues with Yara myself, like her playing loud music, and I've had multiple conversations with her father about her recent behaviour, which seems to be causing a lot of stress.
That's all right. Thank you.
Can you please go back into the comment you made about her father, the issue with her and her father?
We've been having lots of arguments over the past several months.
And how did
It's
you
only been getting more intense and serious, and it led up to that one.
how did you become aware of this?
Screaming, very loud screaming,
And did you do anything about that, or were you just listening?
not much.
So you didn't do nothing. So even though you knew that there was a potential threat, you didn't do anything.
No.
Counsel of Defence.
Okay, first I have to say objection to speculation. They asked that if he thinks. Okay. Secondly, he stated that Yara left. Okay, he heard the door slam and he heard
Members of the jury.
Yara saying that he left. Okay, so this already proves our point by saying that we said that Yara left at this time, which he basically backs us up by saying yes, Yara did leave. Okay, and again we have the proof from the live 360, so she was not present at this time. Next, when he heard the screaming, it was around the time period that he stated he heard screaming, but did he hear anyone go back up? Did he hear Yara go back up the stairs, open the door, and then kill her dad? No. So this is basically speculation. He thinks Yara killed her dad. He thinks he saw Yara go up, and he thinks that he saw or heard Yara stabbing her dad, okay? So this will say objection to speculation because he thinks. He is not certain about any of these facts. Thank you.
Your Honor, may I just add, as you already accepted our evidence of the Life 360, it said that Yara was still at Ed Square Cinemas at 10:15. So how is it possible that she was able to kill her dad and somehow magically reappear at Ed Square at 10:15?
Thank you. Crown prosecution, 1 point of objection. from the counsel of defence.
Um,
Please make your objection clear to the jury.
we object the first point in which they say that Adim was speculating about the incidents in the night of the murder. Adim was not speculating his evidence. He provided his testimony as the only person who was actually there in the room, in the building when the crime happened. And as he said, I think, we can all say that all this evidence provided is I think. The evidence provided in Life 360 doesn't say that Yara herself was holding her phone as she was walking around. We're not contesting that the evidence is there, but we are contesting that it's possible Yara could have just messaged her friend and told her to take her phone on a walk. Anything is possible.
Can you please go back to what was your main objection? Was it relevant?
We were objecting speculation.
Okay,
Adim did not speculate.
you're objecting speculation, but then you call stating the point of I think. That's linked to objection hearsay.
Hearsay?
Yeah. So
Okay.
do you want to go back into your objection and
We can
confirm
go back.
with the jurors which objection do you want to take? Do you want to take the objection of hearsay or do you want to take the objection of speculation? You decide.
Let's do hearsay. We object to hearsay speculation. Hearsay is basically him saying I think rather than I know.
I now call upon Admiral Otto to come forward and say his case.
Good morning, Your Honour and members of the court. My name is Ahmed. I don't have a close relationship with the accused or his father, but I've seen him around in the neighbourhood and occasionally exchange quick greetings.
Any more detail or are you happy with them points?
You want me to talk about that?
Please.
On the night of the incident, around 10 p.m, I was asleep in my bedroom when I suddenly woken up by the sound of a man screaming with concern. I got up and looked out of my bedroom window, which faces the apartment from my window. I believe I saw the son attacking his father in the kitchen. I was still quite sleepy when I witnessed this, and because I wasn't wearing my glasses, I didn't see everything clearly. I quickly went to grab my glasses, but at the time I returned to the window, I couldn't see anyone. That's it.
Ahmed, did you drink anything before you went to bed? Any wine or any alcoholic beverage?
No.
Do you require glasses to see clearly?
Yes.
Yes, you do. So do you think that may have impacted your vision in what you saw?
I could say so, yeah.
So members of the jury, please pay attention to that point. I did ask him, do you think that your vision may have been impacted in what you saw? And he agreed. But please be very mindful of what he just said. He has just agreed that his vision may have been impaired. Crown prosecution, any comments, any cross-examination, please?
Alright. So, what prompted you to look out of your window on the night of the incident? Not what you saw, what prompted you to look? What did you hear?
I heard the sound of a man screaming from across the street.
Across the street. Would it be around the area where the accused lived?
Yes.
Can you describe briefly what you saw when saw in the kitchen of the victim's apartment and what you saw?
I believe I saw the son attacking his father in the kitchen.
Alright, just to confirm, he was not wearing his glasses, so it could be, could not be, but he did hear, Yara's father screaming, so that's what prompted him to look out the window. What did the accused, my bad. Were you familiar with the people living in the apartment across the street?
Not in. I had no close relationship with them.
Were you able to identify who you saw attacking the victim?
No.
That's okay.
Thank you. Counsel of Defence.
So, starting off with just, I feel like adding on, I guess, to what they were saying about the sleepiness and witness credibility. So, you said you were sleepy when you woke up and believe you saw the son killing the dad. Is that right?
Yeah.
Okay, so basically, this is under Section 55 of the Evidence Act 1995. The witness admits to being in a state of sleepiness, right, which undermines his ability to accurately observe the events. Yes, he heard the scream, but did he really see the act as free as happening? Did he see the action happening? No, he did not. This directly impacts the reliability of this testimony. The combination of sleepiness and also just drinking potentially impact the perception, cast doubts on his credibility. Thus, his reliable evidence as its probative value is diminished, as again seen in section 55. And also, again, he requires glasses, so how can we believe that this testimony is reliable?
I'm just going to make one comment regarding our witness. Can you confirm that you were actually sleepy at the time and you don't have 100% capacity to actually see?
Yeah, I was.
Okay, with regard to this evidence, we will throw it out. Please remain seated. This evidence will be thrown out, so therefore what that means is everything that Mr. Haftar just said, we cannot accept it.
I'd like to call upon Diane, the father's solicitor, to come forward and take this.
Can you please outline your role and any information you may feel that the jurors will need to know?
So I am the solicitor of the deceased, and I've handled the process and the process of his last will and testimony, specifically the father of the defendant.
Okay, you mentioned you're the solicitor. What exactly was your role with the accused? What's the relationship between you and the accused?
So I don't have a direct relationship with the accused. I have a direct relationship with the victim, the father of the accused,
Yep.
and I have handled the processing of his will.
And how much was the amount in his will?
$3 million.
So with that 3 million, if, for example, considering you filled out the paperwork, who was that money going to if something had happened to the father?
If something had happened to the father, that money would instead go to the victim's mother, Viara.
Do you have a copy of the will?
We don't have online copies.
So the sum of 3 million was going to
It's the highlight.
is to inherit the full value of my life sentence, and that's the accused. However, should the accused become a convicted criminal, the full value of my life insurance would instead go to his mother. Now, members of the jury, please go down to exhibit 2. Please pay attention to
The
the highlighted section. I will read it for all individuals. The provisions of this will. My son, Yara Abbas, being the accused, is set to inherit the full value of my life insurance worth 3 million. However, should he, Yara Abbas, become a convicted criminal, the full value of my life insurance would instead go to his mother, as we saw, Yara Ahmed. So members of the jury, please pay attention to what is highlighted. Continue.
And Mr. Hoblos, the defendant's father, decided to make this specific amendment on the 1st of December 2023. So many months prior to the taking place of the murder.
Can I please call upon, remain standing, Biara Ahmed. Considering you're in this will, was this discussed that if something happens to your son, you would get that 3 million?
Yes, Your Honour, it was because I was present at the time of the will.
So how come you didn't mention the will when you gave your statement?
No question was asked related to the will.
But it's a will, so obviously it does say here, however, should he, Yara Hablas, become a convicted criminal, the full value of my life would instead go to his mother, Yara Ahmed. So that's saying that you knew that if your son becomes a convicted criminal, you would get 3 million.
Can I just say, during the proceedings of this trial,
It's not a matter of the proceeding of the trial, is that correct?
that is correct, yes.
Take a seat. Crown prosecution.
Alright, Miss Bale. Can I call you that? Miss Bale?
Yes.
Alright. You said that you're the victim's solicitor, right? You handle all of the legal procedures and documents. How long had the victim been consulting you about his will? Like, when did it start? When did he start trying to make adjustments? And
This specific adjustment to his will was made on the 1st of December 2023.
could you reiterate the date of the crime?
The 21st of April 2024.
Alright, so we have a couple of months in between the will being changed and the crime occurring. Let's talk about why the will was changed. What did the victim tell you was the reason?
So the victim told me, Mr. Hoblos, me and Mr. Hoblos did not have a very close relationship. Our relationship is very strictly professional. So he did not provide me exact details as to why he decided to change his will.
Alright, in our evidence that we received, we were told that he feared for his life. And that is why he brought up the amendment to the will. And he brought up life insurance. Can you confirm that?
Whether or not that is true, I don't know, because as I have stated, our relationship was strictly professional.
Alright, so you cannot tell us why he put in $3 million in life insurance.
No, I cannot.
Alright, let's talk about when he actually did this. When he wrote in the additional provision that if his son, Yara Hoblos, became a convicted criminal, the full value of his life insurance, meaning $3 million, would go to the mother of his child, who, as she testified previously, has not a good relationship. Can you tell me why that happened?
As I have repeatedly mentioned, our relationship was strictly professional and these kinds of details were not disclosed to me.
Are you sure?
Yes.
He never mentioned any reasoning as to why he put $3 million in the name of his child's mother, and specifically wrote in the will, adding onto something that would never be a regular occurrence in a will. If my son ends up murdering someone, if my son ends up becoming a criminal, the money goes to his mother.
Respected prosecution, I have repeatedly mentioned that my relationship to the victims was strictly professional. These kinds of matters were not discussed.
Alright, tell me about the victim's wife then. You met her, I'm assuming, when you were signing the will. Can you tell me about her demeanor in front of the father?
Generally, they had quite a cold demeanor to each other, obviously, since they are divorced, so they're not very happy with one another or friendly with one another. But other than that, I cannot provide you any evidence.
Let's say objection, pressuring the witness.
Reject.
Your Honor, I would like, as a member of the jury, I would like to reiterate that a man does not change his will 4 months before his murder to disinclude his son on the specific grounds of if that son becomes an offender. And he does not give $3 million to his said convicted murderer's son, mother, that he's been divorced for the past 15 years? Can you confirm that? 15 years? Divorced for the past 15 years with evidence of not having a good relationship. $3 million. And all of that for what? Because he felt like it? I don't believe so. Also, let's talk about the fact that Mr. Hoblos here had no idea about the life insurance. Who's to say that
Crown
Mr. Hoblos...
prosecution, can you confirm the accused? You're saying you had no idea of the life insurance of $3 million.
Yes.
But when your name is on a will, you also need to be a signing party.
Yeah.
Oh. But you're saying that you didn't know about this will. You're 18, but you also need to be a signing party.
being changed to the.
Yeah.
I'm pretty sure she wasn't.
The question is for the accused, and only the accused to answer. If the accused can't answer, I'm passing over to the defender. So my question is, you were not aware of a will you're stating. Your name is on this will. Any party's name that is on a will there needs to be signature. And you're stating that you were not aware of this.
No.
Defense, only 1 point you can bring forward here.
Can I just bring up the fact that, okay, if her name is on the will and she was not going to get this $3 million that was changed in this 4 months, if she was not going to get this $3 million, it was going to go to her mom, what motive would she have to murder her dad? She's not going to get the money. She's going to be a convicted criminal.
My question is about the signature.
I'm not sure about that.
That would be
Your Honor, I would also like to...
Can I also just question 1 point here? Additional provisions. Why was this additional provision added?
as in the reason behind it.
Yes.
As I have mentioned repeatedly, I was not given a reason.
But if you're adding an additional provision on a contract, you need justification. You surely cannot tell me that you were not given a reason of why it says, should the accused become a convicted criminal, the full value of my life insurance would instead go to the mother.
Mr. Hobos was made very close on that regard.
Your Honor, this does not align. It is inconsistent with the evidence.
My apologies, I'm gonna throw out your evidence. That evidence members of the jury were not accepting. Because it doesn't make sense for an additional provision to be added into a contract where the witness cannot justify it. So therefore, any evidence that Leanne has just given, we're throwing it out. Counsel, next. And now, before we send the jury for deliberation, the process will now be, we've gone through all our witnesses. There will be chances of any final remarks. However, final remarks will come from all parties that have been involved, meaning prosecution, counsel of defence, and we will go through witnesses. However, this is not a time for them to stand here and repeat the whole scenario. If there's anything else that you would like the jury to consider before they deliberate, now is the time. The timing of your final remarks will be 1 minute. So we'll start with the prosecution. And please note, these are the final comments to the jury before they make their decision. Cross-examination. Sorry, one more person. State your role, please.
My role, I am the girlfriend of the defendant, Atifa, and on the day of the crimes that allegedly occurred, I was at a movie with Yara Bloss, and we were together from 8 o'clock to 10:15.
Cross-examination by the prosecution, please.
Alright, Atifa. When did your relationship with the defendant begin?
In high school.
In high school? You're still in high school, aren't you?
No,
18?
18.
18?
Yeah,
So you graduated, right?
Yeah.
So you had a secret relationship from what ages in high school?
Like from year 11.
So from
So like
17 to 18?
16, 17, 18.
So you've had a relationship for 1 year and you're pretty solid, right?
Yeah.
You'd say you love him?
Relationship for 1 year or 3 years? She
1
said
year.
she's been here from 16.
Yeah, from like
And now
16, 17 to current now.
Do you remember, is it 16 or 17?
Objection.
So
17. We're gonna take that as 1 year.
Okay.
Give or
good.
take a few months.
Okay,
Alright? So you've been in a relationship with the defendant for 1 year, and you went out for a movie together.
Mhm.
You recorded yourself going to the movie. You didn't record Yara because you were on the way to the movie. And Yara met you at the movies from Denham Court, which is 8 minutes away from Event Cinema.
And just confirming there was no CCTV footage of you two being together.
Nothing of you together.
From the court.
Which is not public.
The photo, we did not accept that evidence.
But there was the live 360 of Yara being at
Could I get all year 3, 4, 5 and 6 Quran competition participants to the main room, please? All year 3, 4, 5 and 6 Quran competition participants to the main room now.
Let's talk about the Live 360 actually. Live 360 is enabled on each other's phones, correct? So when Yara messaged you at 7:45 p.m., as you stated previously in your testimony, he texted you to meet up at the cinemas and give you the phone, correct?
What phone?
The phone that he used to text.
Any of the messages did we mention a phone?
No, that would be stupid.
Then how would he communicate that to me?
In person. What I am trying to ask
Are you
is,
asking
did
me?
Yara...
Are you asking
There
me?
needs to be, remember, when it comes to cross-examination, we cannot let emotions get in their way. You will ask the question, witness will answer. Okay? And most importantly, the jury needs to actually understand what you're asking, because this is the final witness who will actually answer. Any question that you may ask, I can reject as well.
I'm going to ask a question. It can be rejected if you believe it's speculation, because it might be, I don't even know. But when you met up with Yara at the movies at 8,
Approximately 8, yeah.
you met approximately at 8. That gives Yara 8 minutes to walk after sending you that text at 7:45 to Event Cinemas Ed Squares. Because we've checked, it takes 8 minutes to get from Denham Court to Event Cinemas Ed Square. So if Yara met you at 8 p.m., give or take a few minutes because, I don't know, traffic, pedestrians, a dog walking across the street, who knows? You met there at 8. There's no evidence to prove prove that you were there from the duration of 8 to 10:15, correct? Because your video is taken before the events even happen. Your video is taken before you even meet Yara. So we don't have any definitive proof you met Yara
I
at
have proof that Yara was present in that vicinity from 8 to 10:30 to
You have
10:15.
proof.
The last proof.
You have proof that Yara's phone was there.
Which indicates
You
that she
had
was
plenty of time. I want to ask you this direct question. Did Yara give you her phone?
No.
Did Yara give you her phone
No.
at any point?
No.
During the movie?
No.
Alright, that's.
With the prosecution, can you explain why you're bringing forward the mobile phone?
We're bringing this forward because we believe Life 360 is an app, alright? Everyone here knows, except maybe you're on it. It's an app on your phone where you can track the location of another person by having like your friends sort of just have you on that app as like a
Location
relationship.
tracker.
A location tracker. That tracker is placed in the phone, not in the person. So what we really have proof of is that Yara's phone was at Event Cinemas at Square for that duration. And we have reason to believe that this person that she's been in a relationship for 1 year, is that Yara has given the phone to Atifa, met up at Ed Square, and then gone and done whatever she wants because we don't know what happened at Ed Square. We
So
know.
are you stating, just to be clear for everyone,
according to the crime.
okay, so you're stating that
Did you mention
she
that?
had, excuse me, so you're stating that her partner, okay, was holding her phone in the cinemas while she had gone out to commit the crime.
Yes, I believe so.
Okay, the members of the jury will need to be very clear on that. So what the prosecution here is stating is, okay, two parties met up, obviously the accused and the partner. The accused will say, take my phone, hold it, whereas she'll go back and commit the crime. Majority of the time in my experience as well, people don't really give one another a mobile phone to say, hold my phone, and then we go commit the crime. However, this whole idea of a location service, that could obviously hold some weight. So continue.
The reasoning for this, before you start objecting, the reasoning for this is because number one, the tracker in the Live 360 app is on the phone only. We know that, here are the facts. We know Yara was angry. We know Yara texted Atifa. We know they've been in a relationship. They're able to understand each other. They have motive to cover up for each other. Correct?
But what's the proof they have motive to cover up each other? What's the proof when you
So
make
my
that
mom
claim?
is executive compromised just because I'm his girlfriend?
But my question for the Crown, excuse me, my question for the Crown is, what's the proof to say that they will actually cover up for each other? You're making these claims, but even though it's boyfriend, girlfriend, whatever the case may be, but how can we, to the jury, prove that they definitely have planned this?
This is why I said you can reject it on grounds of speculation. This is a theory I'm proposing.
Okay. Thank you, Crown. Defense.
So I'd like to ask, was Yara ever violent?
No. With my experience with her, she's always been very gentle, even if she has like arguments with her friends. She's never raised her hand. She's always been more like a gentle person.
And do you believe throughout the time you guys at the cinemas, Yara was able to calm down, come to us?
Definitely. We were together. We were like hanging out. The whole reason why we hang out together, we went to the movie, was so that I could cool her down. Yes, I dated her for 1 year, but I cared for her. And I obviously wanted to make her feel better. So we were together and she felt better.
Okay, and so would you say when Yara re-arrived at her apartment at 10:30, do you reckon she would have been calmer,
Definitely. She was in a much happier state. We just finished the movie, we had food, we were together, we enjoyed each other's company, and yeah, she was in a great mood.
When you first met up with her at the movies, was she so frustrated, like she had the intent to kill, or was it just
She
frustrated?
just seemed
in general?
annoyed. Like with anyone, when you come out of an argument, you're not going to be in a happy state. So the reason why I was with her was to calm her down and just, distract her from whatever happened. And at the end of the night, she was feeling much better.
Yeah. Okay, that's all. Thank you.
Crown prosecution, you have only one area which you can object. After this, we'll rest your case.
Your Honor, members of the jury, we object to the fact that the defense says that they watched a movie. We do not have any credible evidence. They may have been in Ed Square. They have live 360 of the phone being in Ed Square, but they don't have any evidence that a movie was watched at Ed Square.
Just be mindful of one point as well I want to go back to. There was no CCTV footage out. So members of the jury pay attention to evidence rule. There is no CCTV footage to say that both parties were actually at the cinema. Whether it was a technical fault and whether it was the actual case, but the problem here is there is no footage to confirm that both these two individuals walked into the cinema at a certain time and both of them walked out at a certain time. You have one chance to object what they've said.
May I just add that you say there's no evidence of them being at the cinemas, but there's also no evidence of them of Yara re-entering the apartment and killing her dad at an earlier time. As the police, they should have investigated that and found cameras, but unfortunately they didn't. So you also cannot say that they went back and killed if there's no evidence of them going back. Thank you.
Okay, now what we'll do, before we conclude the trial, before we actually go to the jury, is there any witness here besides prosecution and defence? They've obviously taken their oath. Is there any witness whatsoever that wants to take a stand and mention any last points before the jury deliberates? And this doesn't mean the Crown or defence. This is completely up to you. Anything? No. Okay.
This concludes today's proceeding. The jury will now deliberate on the verdict.
What we'll do, we'll take 5 minutes. I'll go in with the jury. We'll take 5 minutes to deliberate, and we'll come out exactly 2 o'clock. Okay, jury.
The jury has reached a verdict.
Okay, now, just to finish off, to finalise, I'll call every single one of the jurors. They will stand, he or she will stand, and they will give the verdict. One may say guilty, one may say not guilty. However, the final decision will come down to a majority verdict, and it is only he or she can only guilty or not guilty once that tassel will actually hit the table. So remember, one thing in the criminal trial process is that the judge can overturn the decision. Juror number 1, please stand. Do you find the accused guilty or not guilty? Not guilty. Juror number 2.
Not guilty.
Number 3.
Not guilty.
Number 4.
Not guilty.
Juror number 5.
Guilty.
Juror number 6.
Why the accused not guilty?
Juror number 7. Number 7, please.
Not guilty.
Juror number 8.
Guilty.
Juror number 9.
Not guilty.
Juror number 10.
Not guilty.
Number 11.
Not guilty.
Number 12.
Not guilty.
So based on these facts, and again, like I said, these are just members of the jury, there was a majority verdict. The majority verdict went to 12 to 2. That means 12 members found the accused not guilty, 2 members had only found him or her guilty. Before we give that official verdict, can I please ask juror number 5 to stand? Why did you find the accused guilty?
To me, the evidence speaks for itself. I think everything was just stacked against the evidence.
Okay, thank you.
The evidence was just in shambles, you know.
Juror number 3, please stand. Juror number 3. Why did you find the accused not guilty?
The evidence was inconsistent. It was mostly rejected, and
Yep, only 2 pieces were rejected.
but there was only like 4 evidence in total. There was not enough evidence to support this case.
Thank you. Juror number 8, please to conclude,
I didn't even know about her.
this
Just
matter,
about her.
this matter will require a trial for another offence. You're a member of the jury, be hand down. Now, the accused, we'll finish off. Now, the only reason why I state that this matter will actually mean that we go for another trial, because during the criminal trial process, there was one thing that came to light. And the one thing that came to light is the will. In the will, there was a point where it stated where the accused is a convicted criminal, that 3 million will go to the mother. Therefore, the retrial will be against the mother. However, as for the final verdict, we now find the accused not guilty.